Matters bail, bond and jail. Very contentious, I must say, even as we go through them here. Before we continue with the discussion, let's take a look at some of your feedback. These are your thoughts, 2242 being the SMS line, and the hashtag is Daybreak. Let's start with some of your thoughts. All right, comment from Eldred. It's always said justice is all about fairness. Today our legislators will be attending their Kamkunji to try to wrestle back their hefty house allowances. Yet this is an issue being canvassed in our courts. Actually, it should be before the courts. This is misuse of power. What should an ordinary citizen do when having an issue in court to achieve the same? LSK should be leveling some of these hurdles. Wow, they're saying some of your members are part of cartels. Okay, we'll give you a chance to respond to that.
Joroge says, Wahiga, I've noticed a trend in the judicial system where criminal cases are hard in the nature of civil cases. When a judge is given notice of perjury in the evidence, why should he continue hearing the matter instead of first calling for an investigation report from the police? And you continue to say that is some of the reasons we have this backlog in the judiciary. In a suit where the title deed is forged, the directorship of a company is by impersonator. Why should a judge take 5 years dealing with the matter as a civil case?
Okay, we'll see who of our panel wants to handle that. Wambugu from Nairobi. Morning. If I had been sentenced without having done anything and I had no lawyer to represent me, on which grounds can I be released? Okay. Joy, maybe you'll tell us what you think about that.
Yeah, you don't leave a name, but you say, I do not trust LSK, that's the Law Society of Kenya. I had a case with Rift Valley Law Society in Nakuru, but corruption took place between the lady of that office and the person accused. The lady later decided to resign after messing my case. Now my kids are in children's home. I'm hospitalized after being assaulted again.
Okay, those are very strong allegations to make, though. I hope they can prove them. Somebody else here says the judicial system has never been fair. At a case of being accused of stealing 1 million shillings, the magistrate gave me a bond of 2 million shillings. I see people of high caliber being accused of stealing trillions, but bonds are less than mine. All right. Let's take a look at a few more before we get some thoughts of our panelists. This is tweets now.
And Brian Bwana says, my mom was murdered. The suspects were given quite lenient bail. They still walk around boasting of how much worse they can do. Judiciary is the weakest link in the quest for justice.
Very sad.
So very sad.
Okay, George Ngare, simple formula. We give this, this is in referral to what we were talking about earlier. We give seats to women who gather the highest percentage of votes, a sum total of votes available in their constituency. If we need 20, we get the best 20 from across the country. The matter of gender equity, which we were discussing a bit earlier on. Do we have any more?
All right. Engineer Lazaro says, new constitution giving judiciary powers to do their business independently. Their worst enemy is just corruption. Let's speak the truth. All right.
Okay, and Lillian and a couple of numbers to that name. CJ Maraga has qualities of politics. He will likely join politics when he retires. Okay, someone sees into the future. All right, Wilson, you had wanted to speak before we took that break. We can give you a chance now to...
I wanted to say something to do with what Kakai Kisija had said. And when you're talking about access to justice, it is true that we have many courts now. People can be able to access the court. But justice is not merely accessing the court. Justice is actually ensuring that justice is ultimately done. That's what we are saying. When we are talking about delayment of the cases, having cases expedited in court is one of elements of access to justice, and that has to be ensured. The other thing when you're talking about accessing justice, that the justice is ultimately done, we have issues with that, because that is part of the litigations we've so far taken to court, to do with the miscarriages of justice. And some of these cases that we have actually conceived in prison that have pushed some of the jurisprudence in the court, like the recent case of Muruatetu, that was a stamp of authority of another case of Kaberia and 11 others that declared mandatory death sentence unconstitutional. When we are talking about miscarriage of justice, the case that we had here of one man who has his wife and a daughter had conspired, and those issues are about accessing ultimate access to justice. Just because you have gone through the legal process and you've come to the last court doesn't mean that one now means that you have accessed justice. It is not in the trial journey but that the fact that you can be able to go back to court when there is clear evidence that miscarriage of justice somewhere is there. So those are the issues we want to bring the reform in the criminal justice system in terms of the institution and the law. Number two is about when we are talking about the resentencing. The one that you have just talked about. Again, it formed part of the constitutional petition that we say. And that is because some of the cases really, if you look at the content of the responsibility, criminal responsibility, it doesn't match really the sentence that is so enormous. You know, death sentence with somebody who just snatched the phone. And we are saying this cuts across the board. Mm-hmm. The sentence must match the criminal responsibility. Mm. And again, there is the sentencing in the court must complement the objective of punishment. In prison, what do we intend to achieve out of sentence, out of punishing people? Is it transformation of the offenders? If it is, then let us give them a term which we believe will be sufficient for those people to transform and become now people who can be reintegrated back to the society. Yeah. That is part of the very sentence we are talking about. The other issue I want to talk about that really encourages corruption in court. You know, this issue of expediting the cases in court. When you lodge an application in court, there should be a time frame when that case should be heard, should be dispensed with, should be determined. If that is not brought up, because some of them are taken as fast as you're saying, you're trying to quote record times, yeah? But some will never be produced until we say, especially for those people who are in prison, you said you are relative to go to court and try to push. So what form does push take? It is encouraging corruption.
It is encouraging corruption.
That eventually people will now start spreading that gospel. This is how I managed my case. Okay. So that one will go to another person. And we encourage that corruption. Okay. That is another process. The last one, I want to talk about the Law Society. The Law Society also has a share of blame because some of the lawyers are taking clients' money and again absconding their responsibility. When they do that, we are supposed to complain to the Law Society. The Law Society is very slow at taking those cases and handling those cases. It's good that
Harriet is here. She's going to respond right now, actually.
And this platform actually has those issues, and I have examples, and we want to address those issues and to have a dialogue with the Law Society so that it can be able to respond to those issues. What I'm saying is, we want to address access to justice. If we want to actually deal with the issue of injustice, lawyers must therefore stop manufacturing victims of injustice on the way.
Okay.
Because the moment you go with my money, it will mean I'll go to court and have case tried without representation, which you concur that there is likelihood of being miscarriage of justice.
Okay. All right, Wilson. And I see Kakai also nodding to that. But we have a caller from Nakuru, Maina. Good morning, Maina.
Good morning, Bicha.
Yes, go ahead with your comment or question, Mr. Maina.
My problem is question of corruption apart.
Yes.
And agreeing with Kakai that we have had gains which we must celebrate.
Mm-hmm.
There is an issue of mental attitude within the legal fraternity.
Yes.
And we need a serious mental attitude change management.
Okay.
There is an attitude that unless you are a lawyer, you have nothing the courts can hear from you.
Mm-hmm.
And yet the lawyers have no facts to the cases. They are just agents of the litigant or the accused. We never give, the courts don't have respect for right of being heard, even if you ask a lawyer.
Yeah.
For instance, I have a case in court in 1993.
Mm-hmm.
I got judgment in July 93. I got a decree 1993.
Yeah.
Until today, I'm pursuing execution and courts have always blocked me.
Okay.
Courts become an impediment when you want to execute, and the lawyers are responsible for this.
Okay.
Then another one is 2010 involving a very important national issue, crude oil.
Yeah.
I cannot be heard because I'm not a lawyer.
Okay, Maina.
The problem we have is then the question of law. The laws are there.
Mm.
The courts don't read the law.
Okay.
Thanks, Maina. We have a very bad problem of attitude change management.
All right, Maina. Kings Maina there from Nakuru speaking to us. And Harriet, I'll give you a chance to respond.
He's made a very strong statement. The laws are there, but the courts don't read the law. I'm not sure that would be...
And he's saying that it's an
fully
attitude
accurate,
change.
and that. But that is his opinion.
And his case has been in the corridors of justice for 16 years.
Yes, and I will talk about...
So 1993 up until now, 16 years, still nothing.
But Harriet needed to respond to this. You saw that text as well?
I saw the text.
Yes. And you can also respond to Kings Maina, by the way. If his case has been there for 16 years, what does that then mean?
All right. Let me start with the text. It's unfortunate if that actually happened to that lady. And
you don't know about any cartels?
Well, the cartels could be there. There are cartels everywhere, including the matatus that we take every morning. So cartels are everywhere. And all these cartels put themselves together to safeguard an interest.
Are there cartels in the LSK?
LSK, as LSK, I wouldn't say they are cartels. Maybe within the membership. And in terms of maybe working with other state offices, but I wouldn't really say there are cartels within the LSK, especially in relation to that particular case, because the allegations she's putting across is that it's something that happened in Nakuru. Now, if indeed it happened, and take note, those are very serious allegations, what other steps has she taken to ensure that whatever she's complaining about has been redressed? As I sit here, we don't have that case with ourselves. And there are various stages.
So she should reach out to you?
She has to reach out, and she can even reach out to me personally so that you take it forward. And you'll realize that in such instances, we have two fronts. We have the Advocates Complaints Commission, which also take up matters disciplinary in related to advocates. And we now have the LSK disciplinary tribunal, which now they need also to put a complaint so that we can address from the LSK side. And just like I said, at times we suffer quietly as Kenyans. You are seated, and there's quite a number of Kenyans we have helped. And even in a similar kind of case, I remember we had to take that particular lady and even allocate an advocate in Eldoret to take the matter up. Interesting enough, when the cases are successful, there is no feedback. Nobody comes back to actually tell you this is how my case went. Yeah. And even if it doesn't go well, they still don't bring that feedback. So there are cases out there which are being handled and you don't get to know. Okay. This particular case, it's very interesting, and maybe from here it's something that we wish to take it up, so that we help this lady in case there are any issues. Okay. And you see, when she's blaming the LSK and we are seated on this other side, we were not in court. We are not even privy to the case. We don't know what happened or what transpired, you know. But from what she has said, it's an issue of assault, it's an issue of kids, it's an issue. I can only make assumptions. Okay.
How can she reach you? What email can she send?
My number is very public.
I don't give out your number on TV, but
I'll give you my number so that you can make her reach out to me, so that we can also advise her and assist her in how to go forward.
All right. Kings, you wanted to come in on this issue, but you're also going to respond to Wilson just a bit, just trying to distribute this the time that we have, because we're running out of time. Very briefly, it's been 26 years, not even 16.
Yes, I'll be very brief on that. But I think there were almost like 3 SMS which were touching on the issue of backlog. Yeah. In the entire of this discussion. And Kings summarized it very well, the caller who just called last. And I will quickly talk about what are the challenges, why do we have case backlog? Yeah. And in most cases you will realize that Kenyans will always blame the institution that is hearing the cases. Yeah. That look, the judiciary which is supposed to dispense these cases is not hearing these cases, or is taking too long. For example, his case is 16 years.
26
years. We've had cases of over 34, 35 and 40 years still ongoing and active in court. But what is the problem? And the problem of our case backlog, or why institutions find themselves in this challenge, is the following. One, there will always be an adjournment by the lawyers themselves. So lawyers will cause. We are all lawyers. We are 3 lawyers here, I think, on the table. We practice. 4 lawyers, actually. All lawyers. We practice in this court. We practice in this court, and we are the first culprit. We will always find a way or a solution of postponing a case. I'm not ready for whatever reasons. Number 2, the litigants themselves, because lawyers are agents of instructions. The litigants themselves will always be a challenge. They are always never ready to produce the evidence, to proceed and all that. Number 3, the prosecution, if, for example, is in the case of criminal cases, the prosecution is a biggest nightmare. They will never be ready to proceed. They will adjourn the cases. So at the end of the day, the judiciary, for example, as the one who is doing the arbitration of the case, will be blamed. Yet there are other actors factors outside the institution that causes those kind of
When you say
delays.
lawyers are agents of litigants, has there ever been a scenario where a lawyer, where their conscience kicked in?
Yes.
And they tell their client what we are
Yes,
doing now
very many,
is unfair,
very many.
because we don't hear those
Yes.
stories. What we see are like lawyers are robots for their
No.
clients.
We
We
get instructions. I have come out of record for acting for clients because they're actually the cause of causing the delay. And then you realize that, look, I can't come out of this. So we now have to understand that the case backlog has got nothing to do with one individual, or it's a chain of events that take place, and therefore it becomes a very big problem. Okay. The other one is the institution itself. We've had challenges in terms of the number of judges, the number of magistrates, how to deal with this, and then causes the backlog. But are these institutions addressing it? I think yes. The judiciary, I'm a lover of the judiciary because I practice in those courts. I have worked in that institution. You can see that they have been always improving in terms of recruiting more judges and recruiting more magistrates. Why? It's because they want to address the very challenge of ADR. But a fundamental issue is the Constitution. What did the Constitution post-2010 talk about in terms of issues of backlog? The Constitution post-2010 has come up with a system, and I would want also Harriet to chip in on this, on ADR. Alternative dispute resolution, where we are encouraging Kenyans, look, court system is not sufficient. You may as well seek for ADR mechanisms. But for us to have that effective ADR mechanisms, you must have proper policies in place to actually govern that. As to whether we have a policy right now, ADR policy in place to govern ADR or to breathe life into the Constitution is an issue that I'll wish to hear from my colleague Harriet talking about it. Just as Joy said earlier on, that Kenya is a very litigious country. Yeah. We are very litigious nation. So we end up now cloaking the court system, but not out of our own land.
Okay. Let me just weigh on that before the point goes. Yeah. The issue of ADR and mediation. Now, look at a scenario where, let me use the best cases, matrimonial cases, property-related cases. Kenyans in particular would come to you and say, let's go to court. You try to talk these people out of court to first try and resolve these cases. They don't want, because we look at court as a feisty, you know, as a winner takes it all, and I must win irregardless. Now, this is where we go wrong even as Kenyans, because where there's a dispute, there are better ways of resolving them. And you realize some of these cases we take to court are very emotive and very emotional. And at times, it's also good to allow the emotions to fizzle off before now everybody comes to the table so that they can discuss these things. And you realize quite a number of cases we take to court can actually be resolved out of court. Make it cheaper, make it faster. Even business-related cases, safeguard businesses. The moment you go to court, you have lost it, because it's the other person seated on the other side who will make the ultimate decision. And it can go either way. That means either party will not be happy. So I would also request that Kenyans at large, they need to reflect and think of, in businesses, how else can we resolve disputes? How else can we resolve this dispute to the extent that we can also save businesses? When Citizen and KTN are fighting, you know, these are very key institutions. How then can we safeguard your brand? You know,
we are not
the
fighting
moment,
though, but
let's
for
purposes of illustration.
Purposes. All right. Let's bring in Moses Biano from Kirinyaga. Is calling in. Moses, good morning. Good morning, Moses. All right, we seem to have lost Moses there. Joy, Martin Jue says, is anticipatory bail a barrier to access for justice? How does one know they want to be arrested so as to get this bail so easily?
They want to be arrested.
That's how they get the anticipatory bail. Has this actually been misused?
Yes, I think Wilson gave it a term. I think he called them sexy laws. There's some laws that are cushy. There's the people who've gotten orders against investigations, that the police should stop investigating me, or you get orders, no anticipatory bail. You realize, hey, Bana, this thing is going, I might end up in Kamata Friday, so before Kamata Friday comes, here, I already have bail. So it's one of those things where that's the motion of the day.
But
where
can
the
this be accessed by a common mwananchi?
If you've got the lawyer and the money to pay the lawyer to go and apply for it, yes. But if you decide, oh, I think I'm going to be held, I'm going to court, give me anticipatory bail, they look at you like you've lost your mind. So it's one of those things where...
So again, it's about whether you can afford it.
It helps people who can afford it. But there's a point that Kissinger made that I want to just buttress. If you look at our statistics, one magistrate, we have one magistrate for every 120,000 Kenyans. You've got one high court judge for every 350,000 Kenyans. If you look at those statistics, okay, don't even look at 7 Supreme Court judges for how many million Kenyans. If you look at the statistics, our judiciary is grossly, seriously understaffed.
And underfunded.
And they don't have enough money to even do that. There are places where you have judicial officers appointed and allocated, but there are no courtrooms. So people are sitting in chambers, others are sitting in open courts, others are sitting in rotation in open courts. It's ridiculous. It's one of those things where, like he says, the players outside the system contribute to the mess that is within the system. That is one. Secondly, our criminal justice system, we are talking about alternative dispute resolution. Let's take, for example, the maslaha system that is under Sharia law. You can compensate somebody for any crime, whether it is rape, whether it's murder, whether it's everything is capable of, we sit down, let's agree. But what happens? If we say that in sexual offenses now, maslaha is acceptable, feed the people beginning with me, be like, no, for rape, somebody must go to court, somebody must. And it's that adversarial nature, even of Kenyans. We are very, everything is a fight. You know, the statue of the president, the former president is on the notes, now it's a fight. We fight over everything. That is part of what has curtailed our system. How did Rwanda deal with their backlog after the genocide? Is you put in the gashasha. It doesn't matter what you did, as long as there's restitution and reconciliation. And there is a case for Kenyans to talk about restorative justice, not just about justice in the sense of what the courts have. In some cases, I believe justice is not even served, because if at the end of the day, for example, the family is split, and there's no reconciliation amongst the members of that society, you haven't achieved anything. We need to even change our mindset and say, you know what, if we are going to apply ADR, let there be no gray areas. If somebody is willing to accept 30 camels for the life of his son, and he's at peace with that decision, the rest of us should be big enough to say, you know what, that is your decision, and we respect it. But right now, the law says you shall, you must, you must. Going back to our law reform, we must come to a place where we deconstruct it, because the backlog in the courts, every year over 500,000 cases are filed. They're already finding this backlog, and you're adding 500,000 into the system.
Although there are those who say that
some of the examples are very extreme.
Some of those examples have led to trampling of women's rights, for example. You know,
no, that is
right
true,
to life in itself.
No, all I'm saying is this.
Yes.
If I, as the aggrieved person, are willing to accept that as I'm happy with that. Let me give my own personal example. My daughter, when she was being born, there was some negligence with the doctor, and she ended up with a disability when she was born. That time I was a sitting magistrate in Mombasa, and my first instinct was, can I just go ahead and sue this hospital and this doctor? That time I was on the bench. I mean, nobody is going to deny me orders. But it is me who sat down with my husband, and we made a decision. You know what? She's alive. I am alive. That is what is important to us. And we decided to let it go. To this date, we actually have a relationship with the doctor, and with the hospital, I can still walk in. But imagine if we had gone and we got this decision and her career ended. And yet she's actually a very good doctor. But in my instance, there was just an issue. If the individual is willing to say, you know what? Yes, it was something wrong, but I am happy to let it end here. The rest of society should honor that and say, you know what, that is absolutely fine. But when you start saying, oh, it's when we make it more than it should be, then we end up with what we have now, backlog.